Got it? Okay. So now we are going to discuss on section 28, mention of inventor as such in patent. Okay. So what this section is telling us? Okay. So if the controller is satisfied upon a request or claim made in accordance with the provision in this section, that the person in respect of or by whom the request or claim is made is the inventor of invention in respect of which application for a patent has been made, or a substantial part of the invention, and that the application for the patent is a direct consequence of his being the inventor, the controller shall, subject to the provision of this section, cause him to be mentioned as inventor in any patent granted in pursuance of the application in the complete specification and in the register of patent, provided that the mention of any person as inventor under this section shall not confer or derogate from any rights under the patent. Okay, so it says that mention the inventor as such in the patent before the grant of patent if a person makes claim. Okay, so if you make the claim before the grant of patent that this invention was taken from me and I should be inventor, okay, and you prove two things. We need to prove simultaneously. One is that you are an inventor of the invention file, and B, application is a direct consequence of his being inventor. So these two things are there. You need to prove that you are the inventor, and you need to also prove that consequence of his being the inventor. Okay, then controller will make inventor in any patent granted from the patent application. And what is the process? So sometimes it may happen that you are working in some labs or in some company, that time someone can make these processes that he need to be there as an inventor. Or sometimes, say, for example, you work on some project in somewhere and then you left it, and then later on some application are published, and then you see that this published, and where is my name? My name is not there. And then you need to prove that you are the inventor and all those things. So what you can do, you can fill form 8, and it refers to rules 66, pay a fee of 800 or 4,000 for others. So it may, for when if there are joint ventures and two companies are there, and then one company filed the patent not mentioning the other companies together, for then other company can also apply, and that is the fee is 4,000. And who can file? By applicant who claims to inventor, applicant of that person. A copy of claim and a statement is sent to all applicant, and then when you file this, then a copy is sent to all the applicant. Means if there are, say for example, 5 people are there and 6th one want to be included as an inventor, then the notice will be given to all the 5 people that the 6 people he wants to be inventor. And when to file? Section 28(4). Okay, section 28(4) says before the grant of patent. So this section comes before the grant of patent. And procedure, controller may call for hearing, and then can call for hearing. You need to attend the hearing, and then all the evidence and everything will be discussed. Okay. Number 7 says that a person has been made inventor based on section 28, but any other person alleges that he ought not to be mentioned as inventor, he may proceed to controller. Okay, means there are 5 inventors already, and the 6th one says that I need to be inventor, but this other person thinks that no, he is not an inventor, he has not contributed anything. Then there is also provision. Then he also need to fill form 8 and rule 68, and the fee is the same, 800 and 4,000. And who can file? Any other person who alleges that person is not inventor as per section 28. Anyone who alleges that he should not be the inventor, in that case he can do. And when to file? Anytime. Okay, anytime you can file. And procedure is controller may issue a certificate and rectify a specification, and register may call for hearing. So these are the process happens, that controller can issue certificate or rectify the specification and register. And hearing process, as you discussed already, that hearing process is same as the post kind of question. So if you remember those ones, that how the committee is constituted, one is the member, then you need to remember the timeline, when to apply and what to do, how much of fees. So all those things is the same here also, right? Rule 57 and 66 applies. And how do you know a person has become inventor as per section 28? So if we see a pattern and we see this kind of notification, rule 70, it will be written, the inventor of this invention or substantial part of the invention within the meaning of section 28 of the patent at 170 is this and this. So this kind of sentences will be there. So from there we can see, understand that this person became the inventor because he was not included earlier, and then before the grant he filed that his name should be there as an inventor. Okay, any question on this? Is all clear? So so all the things that you are required for you is written here, and you can refer to this anytime. And please refer to the original text from the Patent Act to understand it much better. Okay.